I'm Monica Hakimi. Welcome to AJIL Explainers, Trump 2.0, and specifically to this explainer on the immunity of international organizations. As I'm sure some of you know, we are doing this series in conjunction with the October 2025 issue of the American Journal of International Law, in which we have an in-depth discussion by different members of our board of different aspects of the Trump administration's response to internet and engagement with international law. And today, we are absolutely delighted to have Lori Damrosch here with us, who is a former editor-in-chief of the Journal, a very, very valued member of the board of editors still today, and a colleague of mine at Columbia Law School. And so, Lori, please just begin by letting us know a little bit about what the Trump administration has been doing with respect to the immunity of international organizations.
Thanks so much, Monica. I am following the instructions which were given, which was to talk about the piece that I put in the American Journal of International Law October issue, which is focused on the immunity of international organizations. And we have a theme statement for this panel, which says that one of the many shifts in international legal policy that the second Trump administration has made is to try to change when international organizations can be sued in the United States. And so I want to emphasize that Trump 2.0 is trying to make this change. This administration can only succeed in making this shift if US courts agree with the changed position, or if US courts agree that the change falls within the constitutional powers of the executive branch rather than the powers of the courts themselves or of the legislative branch. Now, which international organization are we talking about? This specific international organization is the United Nations Relief and Works Agency for Palestinian Refugees, also known as UNRWA. This agency is part of the UN system. It has existed since the late 1940s. It has been carrying out functions, including the delivery of humanitarian assistance to Palestinian refugees in the Middle East. And it's been doing so more or less continuously for 75 or 80 years. So the legal question is whether UNRWA is legally part of the United Nations itself, in which case it does enjoy immunity from suit in national courts under the UN Charter and under a related treaty called the Convention on the Privileges and Immunities of the United Nations. We sometimes call that the General Convention. So that convention, that treaty, generally requires absolute immunity from national judicial jurisdiction for the UN, and that means the organization itself, its principal organs, such as the General Assembly, the Security Council, and the International Court of Justice, and the subsidiary bodies that are created by those principal organs to assist them in fulfilling their responsibilities under the Charter. That same General Convention also gives certain high-level UN officials the same privileges and immunities that diplomats enjoy under applicable international law. Those officials who enjoy the equivalent of diplomatic immunity include the UN Secretary General and UN officials with the rank of Assistant Secretary General or higher. Now, in general, officials covered by this level of immunity could not be sued in national courts. In other words, if UNRWA is a UN agency covered by the General Convention, then neither UNRWA itself nor the high-level UN civil servants who supervise it could be sued in national courts, including US courts. Now, in the conversation I'm going to have with the moderators in a little bit, I'll return to why immunity is an important legal question and why the Trump administration's change in position raises a host of important legal issues under international law and US constitutional law. But before that, I need to add that there is another different legal regime which governs the UN specialized agencies, that is, those agencies that have their own legal personality and their own governing treaties and their own specified immunity regimes. So those would include, for example, the International Monetary Fund, the World Bank, the International Labor Organization, the World Health Organization, and many others. They have their own treaties, And there's also a different treaty, the UN Convention on the Privileges and Immunities of the Specialized Agencies. That's the Special Convention or the Specialized Agencies Convention. And that provides rules for the immunities of those agencies. And I just have to clarify that the United States is a party to the UN Charter and the General Convention, but it's not party to the Specialized Agencies Immunities Convention, even though it is party to the founding treaties of many of the specialized agencies, which treaties themselves specify the applicable immunity rules. So we don't need to get into too many of the technicalities, but the bottom line is that whatever the treaty rules are, the United States is obliged to follow the treaty rules, and that's true as a matter of both international law and US domestic law. Now, there's also a statute whose interpretation is at issue. That's the International Organizations Immunities Act of 1945. This statute was enacted just as the United States was beginning to join the many new organizations that were being created after World War II. And the default rules under the statute are first treaty rules, wherever those exist. And if there is no treaty, then the default rule is the same immunity as governments enjoy. Now, I want to explain how UN immunity has operated for the 80 years from 1945 to the present until the Trump administration shifted the US executive branch position. And it did so in a lawsuit that is now pending against UNRWA and several top UN officials in US federal court in New York. So essentially for 80 years, the US position has been that the UN itself cannot be sued in the United States. This 80-year-old position fulfills US obligations under the UN Charter and the General Convention, and the latter treaty expresses that obligation in terms of absolute immunity. Now, there's a simple reason for why the UN itself cannot be sued in member states. The reason is that the UN carries out its functions in at least 193 member states and also in non-member states and other territories. So if the UN could be sued under potentially different laws applicable in some 200 plus jurisdictions, it would be unable to fulfill its functions. And actually, I can add, for the United States, it would not only be the federal jurisdiction, but conceivably also in the 50 states of the United States, for the possibility of 51 different places that the UN could be subjected to differing legal rules, and it would be impossible for it to have the legal certainty to fulfill its functions. So, for that reason, in every lawsuit in US courts in which questions of UN immunities have been raised, until April of this year, the US executive branch consistently supported UN immunity under the absolute standard expressed in the General Convention to which the United States is obligated by treaty. And not only has this been the consistent executive branch position, but every single US court that has considered this question has agreed that the UN itself and UN principal organs and subsidiary bodies created by the principal organs are all absolutely immune from US judicial jurisdiction. So we have this 80-year-long record of cases in which the US executive branch and US courts have accepted this absolute immunity for the UN itself and its principal organs and subsidiary bodies. These cases come from both federal and state courts, and they come from appellate as well as trial courts and from more than one appellate circuit. A very well-known case was the unsuccessful attempt to sue the UN on behalf of persons who fell ill with cholera in Haiti when a peacekeeping contingent from Nepal tragically brought the cholera pathogen into the country of Haiti, where it contaminated the sewage and water system. And when that lawsuit was filed here in New York, the US executive branch explained to the US District Court and the Second Circuit Court of Appeals that the UN could not be sued in the United States, and the courts dismissed those cases. Similarly, we've had cases in which UN employees have had complaints about their treatment. They've tried to sue in US courts, and the uniform holding has been that employees cannot sue in US courts. They have to abide by the UN's internal system for adjudicating labor disputes. And so, on these grounds, lawsuits have been dismissed on grounds of the UN's absolute immunity against the UN Development Program, UNICEF, that's the United Nations Children's Fund, the World Food Program, and the UN Joint Staff Pension Fund, to list a few. So now, turning to the lawsuit in which the Trump administration announced a new position. These are, of course, very tragic facts. The allegations are that UNRWA and its officials enabled the Hamas attacks of November 7th, 2023 on Israel. The plaintiffs allege that their family members were kidnapped and killed in those attacks, and they further allege that UNRWA's activities in Gaza facilitated the horrific acts by providing monetary and material support to Hamas. Now, those lawsuits were filed in early 2024, and in two statements filed under the previous administration in July and October of 2024, the previous administration adhered to the consistent executive branch position supporting UN absolute immunity and agreeing with the UN that UNRWA is a UN subsidiary body entitled to the same absolute immunity as the UN itself. However, in April of this year, the Trump administration reversed this position in a letter addressed to the judge hearing the case. The new position maintains that UNRWA is not part of the UN system in the same sense as the earlier case law that I've cited. Rather, the new position says that UNRWA has a separate legal personality and is therefore ineligible for absolute immunity. It maintains that UNRWA's functions are outside the functions of the creating organization, namely the General Assembly, and that it cannot enjoy the same level of immunity as the General Assembly. And it further maintains that the president himself has the authority to decide this question under the US Constitution and the International Organizations Immunities Act. So to wrap up my opening statement, I just want to say that this change in position is significant not only for this lawsuit and for UNRWA, but also for UN affiliated bodies more generally, and for UN officials, including the UN officers who enjoy the equivalent of diplomatic immunity. This reversal implicates questions of the international law of immunities, as well as the constitutional and statutory law of the United States. So here are just a few of the questions that US courts will have to consider in evaluating this new position. Does the president have constitutional authority to determine, for purposes of US law, the immunities of an entity created by the UN General Assembly? Can US courts autonomously interpret the applicable treaties and statutes dealing with UN immunities? What degree of deference, if any, should the courts give to a new executive treaty interpretation, which was announced for the first time in litigation where the prior administration had twice affirmed longstanding US positions on this same question? And finally, how should the International Organizations Immunities Act be interpreted in relation to the General Convention, which is a subsequent self-executing treaty on UN immunities? So there's more in my short piece in the American Journal of International Law, and I'll say more in response to the questions coming from the co-moderators. Thank you.
Thank you, Laura. That was just a great introduction, and it really highlights how complex and technical some parts of international law can be, right? One of the things about practicing international law that's so fun is you can just sort of move from the big philosophical power questions to times when you feel like a tax lawyer because it's so nitty gritty. But thank you. I have just to start our conversation and to frame it a little bit. Can you speculate at all on the motivations of the Trump administration here? I mean, it seems to me they're somewhat overdetermined, right? And I'd be curious what your thoughts are. So, I mean, one way to think about this is a case about UNRWA, right? And the Trump administration's general hostility to this relief organization and the work that it does in Gaza, right? So the Trump administration has gone after this organization in a bunch of different ways, not limited to this lawsuit. So that's kind of one story we could tell, right? There's an administration that really doesn't like this particular IO. Another perhaps overlapping story might be a broader hostility to the United Nations generally. Like, as you've helpfully pointed out, the ramifications here might be felt for other UN agencies and officials. But that doesn't seem on its face like it would be very troubling to the Trump administration because, again, it's evinced a pretty strongly held hostility to the UN as a whole. And then the third possibility is there something about immunity generally that the Trump administration doesn't like, right? Is it overdetermined?
Like for the president himself. Okay, yes.
Oh, right. Okay, that's a great point. He does like immunity sometimes, right? But you kind of get the idea. Do you have any sense of kind of what's really animating, or is it just purely kind of case by case and ad hoc? I just love your thoughts on that.
So, well, I have to speak in the first instance as a professor of international law and of foreign affairs and the Constitution at Columbia University. And this change of position was happening at the very end of our spring semester. And at the time, naturally, I said this is part of what this administration is doing generally in support of Israel and in support of Israel's policies in the Middle East and in particular in the Gaza conflict, and that it was relevant to all the other things that the Trump administration was doing at the same time, some of which affected us at Columbia. And so that was an initial reaction, but when we put it in the context of everything else that was going on, starting from the very first day of the administration and continuing right through till the present, and I'm sure into next year and beyond, it is the more general hostility, not only to the United Nations as an organization, but to multilateralism more generally and to the whole family of international institutions that has been carrying out governance functions. So I'm going to hold up my show and tell again, just to do a little PR for your journal, which you two have so capably edited for 4 years. The special section that is in this October 2025 issue, in the piece immediately before mine, there's a piece by the section editor, Jacob Katz-Kogan, that reviews what the administration did from the very first day and then marching on through in the early weeks and months of the administration to undercut U.S. participation in a variety of international organizations, including several of the specialized agencies that I've mentioned. So there were notices given of withdrawal from certain organizations. There was withholding of funding. There was requirements of policy changes in order for the United States to continue participating. And as Jacob Katz-Kogan's piece also points out, the administration or the president instructed the Secretary of State to carry out a general review of U.S. policy toward all international organizations and all treaties, not only the ones that create international organizations or provide for their immunities or for dispute settlement, but all treaties, period, going back to the founding of the Republic. So we are in the midst of a wholesale reorientation, and that, as you say, it's overdetermined that if we have an organization that's a UN system organization perceived as having been complicit in the attacks on Israel of October 7th, 2023, and overlay that with a broader hostility toward UN system organizations more generally, then it's overdetermined that this immunity change would have happened. I think I might not endorse, or at least not so quickly, the idea about the administration being hostile toward immunities generally. That would require a fuller thinking through of the Foreign Sovereign Immunities Act, the Vienna Convention on Diplomatic Relations, the Vienna Convention on Consular Relations, and a number of other treaties and codifications of customary international law. And I think that would be a little bit outside the scope of my charge for today, as well as what I've had the opportunity to really think about. And as I alluded also to the constitutional dimension of immunity, I think there will be many respects in which this administration is quite content with articulations of the law of immunities, just not the articulation of the immunity of the United Nations itself or this particular arm of it.
Monica, I know you want to get in. I just have a really quick comment on part of what motivated that. I think you're right, Lori. It would take a much broader analysis, but I will note that the State Department under President Trump has weighed in against immunity of agencies or instrumentalities in cases brought under the Helms-Burton Act, and that's a case that's pending before the Supreme Court now. That was part of what motivated the question. Anyway, much to think about, but Monica, go ahead.
Yeah, I was actually going to ask a similar line of questioning, right where you left off, which is, okay, so I take what you say about sort of not being able necessarily to put this in terms of like the Trump administration's broader approach to immunity, but I'm wondering if you could say just a bit about trends in the international law on immunity more generally. So, like moves increasingly away even from the restrictive position on immunity and limitations on immunity in the United States for acts of terrorism, for example, and efforts internationally to strip states or particular officials of immunity for violations of Jus Cogens norms conducted in their capacities as state officials. And so I guess, the question is should we see this as part of a broader set of trends, both domestically and internationally, away from assuming, let's say, immunity for foreign or international entities in the jurisdiction of any particular state? And so it's like that's the descriptive question. And then the normative question that would go along with it is, should we be open to the possibility of limiting the immunities of international organizations, especially if one takes seriously, for example, cases like the Haiti cholera case that you mentioned, in which international organizations do damage and might not be otherwise adequately held accountable. So both a descriptive and a normative question about sort of like trends on immunity generally in the field.
Yes, so descriptively, we do see the trend that you have very succinctly summarized. If we charted it from roughly the founding of the United States in the late 18th century until here we are ending the first quarter of the 21st century, we would certainly see that immunities in international law have been narrowed progressively, and that trend has picked up in the late 20th century and into the 21st century, and it takes several forms. So the absolute version of state immunity, foreign state immunity, generally held sway in the 18th and 19th and into the 20th century. As foreign states began acting in the market similar to corporations or banks, then powerful economically motivated trends led to a chipping away of absolute immunity in favor of a restrictive theory in which foreign states now generally can be sued on their commercial or other private acts, but not on acts undertaken in a public or sovereign capacity. So we see that trend. It certainly accelerated in the 20th century. And we also see that for diplomats, if the rules on diplomatic immunity were absolute back in the 18th century, there's a modern convention dating from roughly the 1960s or 70s in which the immunity rules are more precisely specified, but they're still pretty strong. So now, how does this affect international organizations? Well, in 1945, the United States had had very little experience with international organizations. We joined a very, very tiny number, nothing as ambitious as the United Nations. We didn't join the League of Nations, for example. So in 1945, when the United States was not only going to join international organizations, but help design them and serve as host to quite a few of them, it was important to specify in the first instance in US statutory law what rules would be applicable here in the US. So the statute that I mentioned, the 1945 International Organizations Immunities Act, basically said if there's a treaty, we follow the treaty. If there's no treaty, then the default rule is that the rules will be the same as those that apply to governments. So if in 1945, a newly created international organization was being analogized to a state or a government, and if immunity was then understood to be absolute, then international organizations were by default getting absolute immunity. It could be a lesser degree if their treaty provided for a lower level. So that absolute immunity was falling by the wayside as regards foreign states in the mid-20th century. And when we get to 1976, the Congress codified a restrictive theory of foreign state immunity into the U.S. Foreign Sovereign Immunities Act. And in 2019, only about 6 years ago, I guess, the Supreme Court took up the question of whether an international organization, there the International Finance Corporation, should retain whatever absolute immunity it might have enjoyed as long ago as 1945, or would we apply the restrictive criteria of the FSIA? And in essence, the Supreme Court said, as a default rule, the change in state immunity follows through to international organizations, and so international organizations should no longer be immune on their commercial acts unless a treaty provides a different standard. And that's a case called JAM versus International Finance Corporation. And interestingly, in that same case, the court said, oh, by the way, this doesn't apply to the UN itself because its governing treaty provides for absolute immunity. And if the creators of international organizations want international organizations to have absolute immunity, they can specify that in the relevant instrument. So that's why the UN and a handful of other organizations with the large number of members that they have and the large wide-ranging kinds of functions that they have, many of which are public rather than commercial in character, are generally preserving this higher level of absolute immunity. So that's a sort of a succinct overview. There'd be a lot more to say on any of those aspects. I think, Monica, you had also mentioned the chipping away of immunity as regards certain particularly egregious acts. You use the Latin term, jus cogens, the sorts of rules of international law that are so important that they can't be contracted out of. So there are some developments in which some courts in some countries have tried to narrow the degree of immunity applicable to states or other entities that are carrying out such egregious acts, but that's a pretty limited trend so far. And as I read that trend, it does not derogate from treaty-based immunities. It would only be applicable in a situation of customary international law or common law immunities, and not to self-executing treaties, which the United States is required by international law to abide by, and which form part of domestic law under our understanding of self-executing treaties here. And these immunity treaties are generally understood as self-executing treaties.
Lori, that's incredibly helpful. Let me just push a little further on the normative piece.
Yeah.
Just
Oh, yes. The normative, right. The normative
personally,
piece.
I'm widely known as being a pretty pro-immunity gal. But boy, I have to tell you, when you read the cholera, like these are really and the allegations, I don't have an independent basis for evaluating how well substantiated they are, but the allegations of working with Hamas in Gaza, these allegations about these are really bad things, right? And they are, or potentially bad things. Again, I don't want to presuppose the resolution of factual disputes that I don't know that much about, but the allegations are awful. And from everything we know that happened in cholera, those just appear to be true, right? That the UN introduced cholera in Haiti and then a bunch of people died. So, I mean, I isn't the normative push here pretty strong to just say to international organizations like, folks, clean it up? Don't make people wind up being dead. And if you do, like, yeah, actually, maybe some domestic courts will litigate those cases. I mean, what's wrong with that view of what's happening here?
So, so, um, so on the normative piece of it, I'm going to associate myself largely with your own views, Ingrid. Both just I'm generally wanting to defend the existing system of immunity, but also recognizing that some kinds of activities are sufficiently bad that there ought to be remedies for them somewhere. And so I want to say a couple things about my general agreement with both of those propositions. So the rules of immunity are not designed to shield the United Nations or any of its personnel from ultimate accountability. And so we can debate on whether the Haiti cholera case was sort of a limiting case for that proposition. We can debate what would be the appropriate reparation if it were true that the introduction of the cholera pathogen into the Haitian ecosystem could have been prevented by better hygiene on the UN's part or should be paid for by somebody. The UN is supposed to have a dispute settlement system that's supposed to handle claims of a private law character. And maybe what's so troubling about the Haiti cholera allegations is that there is a genuine dispute over whether these claims are just like an ordinary tort claim, like I might have a claim against my neighbor if my neighbor poured sewage into my well and I got cholera, or is it more like maintaining a public health system where deficiencies in the public health system might not be something on which you could maintain a claim against your own government or a foreign state, and under the principle of parity here with foreign states and international organizations being roughly on the same level for most purposes. If you couldn't sue your own government for shortfalls in its public health system, or if you couldn't sue a foreign state like Nepal for having failed to put cholera at bay in its own country and having brought it across the Atlantic, if those kinds of injuries would not be remediable as a private law claim, then it's not clear that a UN dispute settlement system would cover that. But let's just leave that as a matter, I think, of fair debate, genuine debate. On some of the issues having to do with the individuals involved. So the treaties that I've mentioned have provisions that are addressed to the obligation on the UN to prevent the abuse of privileges and immunities, and the obligation of the Secretary General to waive privileges and immunities in the interests of justice, where that can be done without prejudice to the interests of the organization itself. And so, again, like you, Ingrid, I don't want to assert facts that would have to be proved in a court of law. I don't want to take positions on contested propositions of fact, but it is known that Israel has made allegations against UNRWA in general and against UNRWA personnel at various levels, and has tendered some evidence about specific members of the UNRWA staff, and some of those staff members were dismissed. And so dismissal for abuse of privileges and immunities is a relevant form of sanction. Criminal prosecution of such persons could be maintained if the Secretary General would grant a waiver to an appropriate jurisdiction. I don't think any such waivers have been granted, and so that may be a shortfall in, or it may be a discrepancy between what the words of the treaty say and the actual operation of the treaty in fact. So we can analogize it to the regimes of diplomatic and consular immunities, where it's understood that the sending state could and should waive immunities and allow individuals to be prosecuted if they have committed crimes in the receiving state. But sometimes that's not done by waiving immunity. Sometimes it's done by withdrawing the suspect and prosecuting that person back home. So there would be various ways to fulfill the goal of having real, meaningful accountability for persons who abuse their privileges and immunities and commit crimes in the course of such abuses. But we either have to find those forms of accountability within the existing treaty-based regimes, or we have to reform those treaties. And so normatively, it might be time to say, after 80 years of this, it's time for a rethink of the whole system, and the immunities rules that seemed to work in 1945 were rethought for the foreign state immunity regime. Maybe we can rethink them more broadly. Terrorism is a particularly tough case. We in the United States have seen the adoption of 2 amendments to the U.S. Foreign Sovereign Immunities Act to enable lawsuits to be brought against foreign states that are supporters of terrorism. And there has not been a corresponding reform of the international law, either as regards foreign state sponsors of terrorism or as regards international organizations or international personnel who might be somehow actively or passively complicit in non-state terrorist activities. So if it's time to rethink it, I would probably be the first to join you in saying, let's design a better treaty. But I don't want us to undermine the existing treaties that we have, because they actually do a lot of good for the world as a whole and for the United States in particular.
Lori, that's again a perfect stopping off point for the question I've been thinking about as you've been speaking about, how we might reform the system, basically. And so the question is, could you say a little bit more about, so one way of looking at what's happening is that the Trump administration has decided that it is going to try to reform the system. It has decided that reform is necessary. It's decided that it's going to take a large strike at the current system and try to create something new. And I guess my question is, could you say a little bit more about why the United States has understood this immunity regime, and I guess more specifically, why the executive branch of the United States has understood the pre-existing immunity regime to be sufficiently in the United States' interests or consistent with the United States' values or agendas on the world stage, so as to justify continuing to insist on it in court over these many years. And that might then help to expose a little bit what might have shifted in the United States' understanding of its own interests and values, and therefore the direction in which it might be sort of pushing the system, whether desirably or not.
Yeah, so that's a very ambitious question, and it certainly goes well beyond the scope of the short little paper that I put in the journal or the thinking that I did in anticipation of the kinds of questions that might be on your minds today, but it certainly is very appropriate. So the United States in 1945 was the moving force behind the design of the United Nations system as we have it. It was understood that the United States was going to play a leading role in maintaining peace, with peace and security being front and center in Security Council responsibilities. And the United States expected to shoulder a very large measure of both the tangible military contributions and also funding the contributions of other UN activities. So we paid a higher share of the budget, for example, for peacekeeping. I think certainly in 1945, whatever one was thinking about absolute immunity for international organizations, peace and security responsibilities were not the ones where you would expect that the major providers of what was then understood as a sort of a benign form of international security might be suable in the states of members that might take a different view. And so if the organization was going to be sued in a country that was the object of a peace enforcement operation, say, and then sued the United Nations, the United States would be shouldering 20–25% of those costs. So if the Trump administration is actually having a total rethink, not only of immunities, but of US participation in these organizations and US funding of them, then we'd also have to be persuaded that the original perceptions of US interests in active participation in these organizations were also misguided. So that's a start at an answer, but it's a bigger question that I don't think I'm going to be able to answer satisfactorily at this time.
As many of our listeners will know, the International Court of Justice has considered a number of issues related to events in Gaza, including the role of UN relief agencies there. I wonder if you could just say a little bit about those opinions, whether it's the advisory opinion or the case that South Africa has brought, and what intersections you see, if any, with respect to immunity before, and just to remind listeners, the kind of immunity we're talking about here is immunity before domestic courts, not in front of international tribunals more generally.
Right. Yes. So there's been a series of these cases. I think we've got now 3 advisory opinions on the occupied Palestinian territory. The first of them goes back more than 20 years. In fact, when I was brand new in the position that you two co-editors-in-chief are now holding, we did for the American Journal of International Law and Agora on the advisory opinion on the legal aspects of the wall in the occupied Palestinian territory. And then we had another advisory opinion last year, and then the third one just issued more or less contemporaneously with the appearance in the American Journal of the special section that we're talking about today, was the advisory opinion. Got the name of it? Hang on. Wait a second. Yes. Well, never mind. the section of the advisory opinion in question, which is about a 7-page section, is called the obligation to respect the privileges and immunities of the United Nations. The whole advisory opinion, it is called Obligations of Israel in relation to the presence and activities of the United Nations, other international organizations, and third states in and in relation to the occupied Palestinian territory. And some people are referring to it as the UNRWA advisory opinion because so much of it does actually deal with UNRWA's presence in Gaza and obligations on the part of Israel in Israel's own territory to cooperate and comply with legal obligations. So pages 56 to 63, paragraphs 180 to 2016, under the heading of obligations to respect the privileges and immunities of the United Nations. A key takeaway from there is that the treaty regimes do not cease to operate in the context of armed conflict. The court notes that UNRWA's mandate derives from a General Assembly resolution of 1949, and that determinations about specific facilities as falling under UNRWA's mandate is a determination for the UN itself, not for any UN member state, and that the immunities of UNRWA personnel are also to be respected. So in this advisory opinion, the court takes note that two participants, we know who they were, Israel and the United States, quite obviously, two participants asserted that perhaps limitations on privileges and immunities may be justified in light of security concerns and alleged abuse of privileges and immunities. And the court took note of the UN responsibility to prevent and address abuses of privileges and immunities. And it concluded this segment of the opinion by reaffirming, and here I'll just read a short quote, "A member has no right unilaterally to revoke the privileges and immunities accorded to the United Nations or its personnel." Now, so what does that, what does that little sound bite mean for the legal issues that are now squarely before the U.S. District Court for the Southern District of New York and ultimately the Second Circuit, maybe eventually the Supreme Court? So an advisory opinion of the International Court of Justice is advisory. It's advisory to the requesting organ, which in this case was the General Assembly. An advisory opinion, by definition, is not binding on states. And it is not even necessarily binding on the General Assembly, but since the General Assembly requested it, it's pretty likely that the General Assembly will pay serious attention to it in forming its own resolutions and action program going forward. As far as its reception in states members of the United Nations, I can only say by analogy how UN members have reacted to the earlier advisory opinions concerning the wall in the Palestinian territory or on other topics. I can say that very often a state that understands itself to be the object of criticism, as certainly Israel would understand here, will reject the advisory opinion, both for its legal force and for the quality of its reasoning. What's going to happen in the United States, I think, my prediction is that US courts are going to recite the same little formula that they have done in state-to-state cases, of which there have been a whole series involving the legal force in US law of binding opinions of the International Court of Justice. And the Supreme Court in half a dozen of these cases has said that a binding judgment of the International Court of Justice is internationally binding, but does not have domestic legal force, at least not directly so. And sometimes the court will say, we will give respectful consideration to an interpretation of an international treaty, by a court with jurisdiction to interpret the same, but we're free to arrive at our own interpretation, as the court has repeatedly done. So I think that if a question of immunity reaches the highest court of the land, it will say, well, this advisory opinion isn't binding on anybody, so we probably don't even need to give it respectful consideration. But to the extent that we do give it respectful consideration, we look at this and we disagree, or we agree, as the case may be. And so here's where I think that the real question is not, will a US court pay attention to pages 56 through 63 of the latest ICJ advisory opinion? I think the real question is, will US courts say that President Trump can decide this for himself and for the whole United States government? And there, I think that they're quite likely to say, no, President Trump does not have that authority. We have significant US cases interpreting treaties in which the courts have said, we will give respectful attention to the position of the executive branch in interpretation of a treaty, but a treaty is a text to be interpreted like any other, and courts can interpret it autonomously. And a self-executing treaty is especially for the courts to interpret. And a self-executing treaty subsequent in time to the International Organizations Immunities Act prevails over that statute. And in any event, if we were going to analogize international organizations to states, already we've had a half century in which the courts have yielded to the expressed position in the Foreign Sovereign Immunities Act that the criteria are for the courts autonomously to apply. They are not for binding decision by the executive branch. That idea that the executive branch makes binding decisions on immunity has been rejected since at the latest 1976. So the Trump idea that this is just a matter of the president's policy choice seems completely incorrect as a matter of US constitutional law.
Lori, that's super helpful, and I think maybe a really good place to start, because I think it exposes something that we've been trying to get at over the course of these webinars, which is the ways in which sort of these technical debates about that are saturated with law actually go to so many of like the high level political questions and geopolitical questions, even more specifically about how what's going to happen with international law going forward. And so by getting both into the weeds and giving us a sense of like the broad contours of the stakes of this decision, like long term and for the United States, I think we've really covered some good ground here. And I want to just thank you so much for illuminating the significance of this case and for sharing your expertise with us. It's always such a delight to see you, and we're very, very grateful for this, for your essay in the October issue, and for everything that you do for the board and for the journal.
I just want to add to that, Lori. Thank you for your 8 years of leadership in the American Journal of International Law. I think being a co-editor-in-chief for 4 years, I have a new appreciation for what it's like to do it for 8 years. And you've continued, as Monica just said, you've continued to be just an incredibly positive force in the field and for the journal. So just many thanks.
Gosh, thank you. Well, I can't thank you guys enough for your leadership of the journal over these 4 years. I'll be really missing your current role, and I know that the journal is going to go from strength to strength, but your leadership has been exemplary, and this series of webinars, I think, is it's a very special opportunity. So I do want to just also say to, I don't know who's participating in this webinar. I imagine that there are some folks on it who know way more about the immunities of international organizations than I do, and I'd be happy to correspond with anybody as well as with anybody who's coming to this for the first time. You can reach me at Columbia, and look forward to staying somehow in contact with the broader universe of listeners. Thank you.
Thank you, Lori.